Good evening, and welcome to our webinar, Debt Management for Business Owners. Our webinar this evening will be presented by Crystal Lindsay of the Lindsay Law Group, based out of Southern California, and I will be your host this evening. My name is Lourdes Macavinta with Wealth Management Financial Advisors. Good evening, Crystal.
Thank you, Lourdes. As Lourdes said, my name is Crystal Lindsay, and I am a bankruptcy attorney here in Long Beach as well as Los Angeles. I work primarily with individual consumers dealing with debt as well as small business owners dealing with unmanageable debt. Today, I will be presenting the webinar, Debt Management for Business Owners. I will be discussing the different options and solutions for business owners dealing with business debt and how each of these options works and will ultimately affect their business assets and debts. Before I begin, I'd like to say that today's webinar should not be taken or construed as legal advice. If you are dealing with debt, whether as an individual or a business owner, I always recommend speaking to a professional, whether that be an attorney or a financial advisor. At the conclusion of my presentation, I will provide contact information of where you can find professionals such as these. Let's begin. As I said, today's webinar is geared towards businesses and business owners. There are really two major options for business owners attempting to manage business debts, and those two options are debt settlement and bankruptcy. When a business is experiencing unmanageable debt, meaning it can no longer afford to pay its creditors, debt settlement is typically the first option that I recommend. With debt settlement, a business owner approaches its creditors with the option of negotiating and settling its debts at an amount less than the full balance. Many times, creditors are open to the option of settling business debts because these creditors realize that they may not receive anything at all, which is commonly the case when a business is in debt and on the verge of closing. The second option is bankruptcy. Bankruptcy is a method of eliminating unsecured, secured, and other debts through the legal system, and that is the U.S. Bankruptcy Code here. Bankruptcy is available to both individuals and businesses and basically provides an opportunity for a fresh start. The primary purpose of federal bankruptcy law is to discharge the debtor from burdensome debts. Before I get into explaining both options of debt settlement or bankruptcy, I'd like to go over some of the warning signs that indicate a business has too much debt and a business's debt has become unmanageable. Business owners should look at these signs, and if any of these signs are present within your business, then it's likely that your business has too much debt. These warning signs include debts that greatly exceed profits and assets. So if your business has more debts than profits, more debts than it's bringing in profit-wise, then this is a sign, of course, that your business has too much debt and has unmanageable debt. Another sign of unmanageable debt is if your business is maxing out any available credit, whether it be credit cards or business lines of credit. If your business is maxing out these available lines of credit, then this is definitely a sure sign that your business is carrying too much debt. Another sign that business owners should pay attention to is if you are only paying the minimum due on your credit card bills each month. If you're only paying the minimum due and you're juggling payments and maybe even stalling one payment to pay another, this, of course, is a sure sign that your business is in too much debt. If you have at least one or more credit cards that is near or at or even over the credit limit, again, this is a sign of too much business debt. If you are a business owner who has recently been denied credit, whether it be through a bank or a credit card company, this is also a sign that creditors aren't willing to extend you credit because they know you are carrying too much credit. They know you are carrying too much debt. If you are ignoring your bills or your credit card statements or even ignoring your credit report, this is a sure sign that you likely are in too much debt. And then lastly, failing to keep up-to-date financial records, including profit loss statements, financial spreadsheets, things that business owners should do regularly and consistently. If you're failing to do these types of things, then it's likely that your business is in too much debt. Before I begin discussing the different options for managing business debt, I want to take a few moments to go over the different types of business entities. This is important because the options for managing business debt are very dependent on the type of business entity that the business was formed under. The four most common type of business entities would be the sole proprietorship, partnership, the LLC, and then the corporations. Under a sole proprietorship, meaning that a business is run and owned by one individual and there is no legal distinction between the business and the person, under a sole proprietorship, the owner of the business is legally responsible for his or her business debts. Under a sole proprietorship, the business and the business owner are basically one and the same, and so the debts are owed by both the business and the individual who owns the business. Under a partnership, and a partnership would be a business that's owned by at least two more individuals, under a partnership, partners are also personally liable for all of their business debts. So when one partner takes out a debt, say a loan for a business, although only one partner may have signed for that loan, all the other partners are still liable for that debt. And then lastly, we have corporations and LLCs. When you form a corporation or an LLC, it becomes a separate legal entity apart from its owners. And in order to file a corporation or LLC, of course, you have to file forms and documents which you submit to the state. If you haven't submitted the necessary documents, then your business is not a corporation or LLC. It's likely a sole proprietorship. Or if there are more than one owner, then it's a partnership. So under a corporation or an LLC, the business itself can own its own assets, it can enter into its own contracts, and is liable for its own debts. One of the main reasons people form corporations and LLCs is to limit their personal liability to business debts. If the corporation or LLC cannot pay its debts, creditors can normally only go after the assets owned by the company and not the personal assets of the business owners. However, it's important to note that a business owner in certain situations can still be held responsible for corporate or LLC debts. For example, if you co-sign on a business loan, you are as equally responsible as the corporation or the LLC to pay back that debt. And this is usually the simplest way to voluntarily make yourself liable for your company's debt, is when you co-sign for the debt. Similarly, if you personally guarantee an obligation of the corporation or LLC, then again, the creditor can also come after your personal assets if the business defaults on the loan. If you have a new company or your company does not have many assets, a creditor will likely require you to provide some sort of collateral before approving the loan. So if you agree to pledge your house or some other personal asset as collateral for the business, the creditor may be able to take your property and sell it to satisfy the obligations of the company. Many business owners fail to realize that when they co-sign for business debt, they are making themselves personally liable for that debt. So we discussed the ways that you can voluntarily make yourself personally liable for a corporate or LLC. I also want to briefly discuss how a creditor can access a business owner's personal assets by eliminating the LLC protection provided by the corporation or the LLC. This is commonly referred to as piercing the corporate veil. The corporate veil is usually pierced if the creditor can show that the corporation or the LLC was merely a shell created only to provide liability protection for its owners, or if the company was practically inseparable from its owners. Courts will be more likely to pierce the corporate veil if the following scenario take place. So if corporate formalities such as holding annual meetings or or keeping official documents. If those aren't followed, then courts are more likely to pierce the corporate veil. If certain owners of the business exert too much control over the corporation or LLC, then the courts are likely to pierce the corporate veil. And then if owners commingle personal funds with business funds, or say use personal funds to satisfy business debts, then the courts are more likely to pierce the corporate veil and not allow the LLC or corporation to provide protection from liability. Next, let's move on to the different options for business owners dealing with high debt. I'd like to begin with debt settlement first. Debt settlement, as I said, is the negotiation and settlement of a business's debts for less than the full amount. Assuming a business can't pay all of its creditors in full, the next question, of course, is how little will business creditors settle for? As you might guess, how little a creditor will settle for depends on the type of creditor, the legal details of the debt in question, and the attitude and position of the creditor. For example, if your business is an LLC or corporation without any personally guaranteed debts, a creditor will know that it doesn't have the option of collecting from you personally. And so in these cases, creditors are more than willing to, or more likely to accept a small portion of what your business owes compared to the full balance. And this would be debt settlement. But again, please note, if you do owe a debt personally, meaning you co-signed it or you personally guaranteed it, then the creditor has much more leverage against you, and in these cases, debt settlement may not be as practical. For my clients, I typically recommend that if you can pay anywhere between 30% to 70% cash of the debt that you owe, then I believe it's worth trying to settle. Many creditors, knowing that they will have a hard time collecting the debt once you are out of business, may agree to settle your debt for 50 or 60 or 70 cents on the dollar, or even less. I've seen some creditors accept as little as 30 cents on the dollar for debt because the creditor knows that the business is on the verge of failing, and so instead of receiving nothing, they're more likely to accept settlement at a lower amount. It's also important to keep in mind that it won't help a business owner much to settle one or two small debts for a reasonable amount while not trying to settle the larger ones. So it might make sense to tell your creditors that your settlement offers are contingent upon all of your creditors agreeing to settle your debts. Also, it's important for business owners to consider the option of hiring a professional, whether that be a company or an attorney, to settle your business debts. In my experience, as well as my clients' experiences, creditors are much more likely to take a business owner's offer of debt settlement seriously if the business owner has taken the time and the resources to hire an attorney to handle its debt settlement negotiation. Also, it's typically easier and much more practical for a business owner to retain an attorney to handle settlements than trying to do it themselves. I also want to touch a bit on the tax consequences associated with debt settlement. So if your creditors agree to settle your debts for an amount less than what you owe, then the IRS and the state tax agencies may view this debt forgiveness as taxable income. In other words, as a business owner, you don't have to pay the money, so the IRS and the state tax agencies look at this as income received. Any creditor who forgives $600 or more of a debt is by law required to report the income to the IRS. Once reported, the IRS will send you a 1099 form, and this could actually result in you having positive taxable income rather than operating at a loss. Owners of corporations and LLCs won't be personally liable to pay these taxes, but sole proprietors and partners, I always recommend talking to a tax advisor to see whether this forgiven income can be applied to previous years' net operating losses, or even otherwise wiped out. Let's now discuss bankruptcy as a solution for managing business debt. As I said earlier, bankruptcy is a method of eliminating unsecured, secured, and other debts through the legal system through the bankruptcy code. Bankruptcy is available to both individuals and businesses and provides an opportunity for a fresh start. In a typical bankruptcy, a business's non-exempt assets are sold and used to pay debts, and the business's remaining debts are then discharged. One of the most powerful features of bankruptcy is the automatic stay. The automatic stay goes into effect as soon as a business files bankruptcy. And what the automatic stay does is it prohibits a business's creditors from collecting or attempting to collect any debts that the business, or even if you file as an individual, that the individual may owe. So as soon as you file for bankruptcy, whether as an individual or as a business, the automatic stay goes into effect, and it lasts until the bankruptcy is complete or until a creditor is relieved of the automatic stay. So once a business files for bankruptcy, its creditors may not contact it until the bankruptcy is complete or dismissed or they're relieved of the automatic stay. There are different types of bankruptcies under the U.S. Bankruptcy Code, and they all fall under different chapters. There are 3 chapters of bankruptcy that a business may file, with each having its own separate requirements and effects. There's Chapter 7 bankruptcy, which is commonly known as discharge bankruptcy. There's Chapter 13 bankruptcy, which is commonly known as the repayment plan bankruptcy. And lastly, there's Chapter 11 bankruptcy, which is commonly known as reorganization bankruptcy. The most common chapter of bankruptcy is Chapter 7 bankruptcy. Chapter 7 is the full liquidation of debts, commonly known as discharge or straight bankruptcy. Under Chapter 7, a trustee is appointed to your bankruptcy case who oversees the selling of any non-exempt property in order to pay debts, and then the remaining debts are then discharged. If there is non-exempt property, the debtor or the business's debts are immediately discharged in the Chapter 7 bankruptcy filing. So if you're individual or business and there are no assets owned by the individual or the business, the individuals or the business's debts are immediately discharged under a Chapter 7 bankruptcy filing. Chapter 7 is available to both businesses, including sole proprietorships, partnerships, and corporations. However, certain businesses, including banks, savings and loan associations, credit unions, insurance companies, and railroad companies are prohibited from filing Chapter 7 bankruptcy. I also want to note that small business owners have the option of filing Chapter 7 on their own behalf or under their business. So if you are a sole proprietor, you must file Chapter 7 bankruptcy personally to wipe out any business debts because, again, you and your business as a sole proprietor are considered the same legal entity. However, many business owners file both personally and under their business because the bankruptcy under the business alone does not wipe out personal liability for the business debts. So it's common that business owners will file both personally and under their business. If you are a business owner, which type of businesses, or not which type, but under what scenarios are ideal for Chapter 7? As a business owner, you may be wondering what situations are ideal for filing Chapter 7. And I want to go over a few scenarios where Chapter 7 bankruptcy would be beneficial for business owners. So if your business debts have grown so large that you know that you'll never be able to pay them back, sometimes business owners find themselves in a position where they know they'll never be able to reasonably pay their debts. In these types of situations, Chapter 7 bankruptcy is beneficial. Another scenario is if you are a business owner who finds yourself in an expensive commercial lease or, say, a sales contract that's preventing you from from operating profitably, then Chapter 7 bankruptcy allows you to get out of these types of leases that you cannot afford. If you are a business owner and your creditors and your bill collectors are harassing you or your employees with collection calls, then again, Chapter 7 bankruptcy is beneficial in these situations because, again, the automatic stay does go into effect as soon as you file, and this prevents any creditors from contacting you until your bankruptcy is complete. Another scenario where Chapter 7 can be beneficial is if your business has lost a lawsuit and you were ordered to pay judgment that is well beyond your business's means, then Chapter 7 is beneficial because you can discharge court judgments as well through Chapter 7. If your business has racked up high business debt and you say you need to lighten the load so that you can pay your mortgage or your car loan or any other expense that you have, then Chapter 7 bankruptcy is ideal because, again, you can discharge these business debts that are preventing you from paying your necessary expenses. And then lastly, Chapter 7 is always a good option if you want to stop, say, a vehicle repossession or a garnishment on your spouse's wages or even a foreclosure. Chapter 7 can stop, at least temporarily stop, all these scenarios. Next, I'd like to move on to Chapter 13 bankruptcy. And Chapter 13 bankruptcy is quite different from Chapter 7. In Chapter 13 bankruptcy, a business is allowed to keep its assets while reorganizing and paying off all or at least a portion of its debts through a repayment plan. In Chapter 13 bankruptcy, the repayment plan is submitted by the business owner and it must be approved by the court. And the repayment plan typically lasts anywhere from 3 to 5 years. During this repayment plan, the business owner makes monthly payments to a bankruptcy trustee who then pays the business's creditors according to the plan. How much you have to pay back in the plan depends on your income, expenses, and the types of debt that you have. Generally, the higher your income, the more you will be required to pay. However, certain debts, these are called priority debts, these must be paid off in full in your plan regardless of your income. And these priority debts include back taxes, any domestic support obligations, anything that's considered priority debt must be paid in full upon the completion of your repayment plan. And then once your repayment plan is complete, whether it's 3 or 5 years, at the completion of the repayment plan, any unsecured debts are discharged. So any credit card debt, personal loans, any debts not secured by collateral, these are unsecured debts and they are discharged once your repayment plan is complete. So who can file Chapter 13 bankruptcy? If your business is considered a separate legal entity, such as a corporation or an LLC, it cannot file Chapter 13 bankruptcy in its own name. Only individuals can file Chapter 13. However, it's important to note that sole proprietorships and certain partnerships are not considered separate legal entities distinct from their owners. So if the owner files Chapter 13 bankruptcy, it will provide the same benefit to the business. Furthermore, even if your business is a separate entity, you still may be able to include a business debt in your Chapter 13 bankruptcy if you are personally liable on it. So again, this is where the type of entity that the business was formed under becomes important. In your Chapter 13 bankruptcy, you must include all debts that you are personally liable for. If your business is not a legal entity offering limited liability, then you are personally obligated to pay its debts. The most common example of this, again, is the sole proprietorship. So a sole proprietor and his or her business are treated as the same person. So all the business debts are included in the bankruptcy. If your business is a corporation or a limited liability company or another separate business entity, you cannot include its debts in your Chapter 13 bankruptcy unless you can show that you are personally liable on the obligation. So again, if you co-signed or if you personally guaranteed a business debt, you you are still personally liable for this debt, and you can include it in your Chapter 13 bankruptcy. Next, I'd like to discuss the benefits to a Chapter 13 bankruptcy. Again, if you own a small business, filing Chapter 13 bankruptcy can help you reorganize your debts and save your business. And Chapter 13 bankruptcy provides several benefits and advantages to help help keep your business running. One benefit is, as we discussed, it wipes out business debts. If you're a sole proprietor, your business debts, again, are not distinguished from your personal debts. This means that you can discharge any non-priority unsecured business debt, such as a credit card, when you complete your plan. After discharge, after your repayment is complete and you receive a discharge, the creditor cannot collect from you or the business. However, if a debt was included in your bankruptcy because you co-signed or guaranteed the debt for your business, then the discharge wipes out only your personal obligation, and the creditor can still go after the assets of the business. Another benefit for Chapter 13 bankruptcy is you pay off your priority creditors. If your business has priority debts like back taxes, then you include them in your repayment plan, and you are given the opportunity to pay these off in full through the repayment plan. And you can include these debts in the Chapter 13. Another benefit for Chapter 13 bankruptcy is the ability to cram down any secured loans through your Chapter 13 plan. So through your Chapter 13 plan, you may be able to reduce the balance of certain secured debts, such as perhaps an equipment loan or a car loan, and you are able to reduce the balance of these secured debts based on the value of the property. So this can reduce the burden on your business by consolidating these loans into your repayment plan and lowering your monthly payments. And then lastly, one of the biggest benefits to Chapter 13 bankruptcy is you can keep your business assets. If your business has non-exempt assets, then Chapter 13 bankruptcy allows you to keep them while you reorganize and pay off your debts. Unlike the Chapter 7 bankruptcy, where the U.S. trustee takes these assets and sells them to satisfy your debts, in a Chapter 13, you are allowed to keep operating your business and pay your debts through the repayment plan. But again, it's important to keep in mind that you have to pay your unsecured creditors an amount equal to the value of your non-exempt assets in your plan. Next, I'd like to move on to Chapter 11 bankruptcy. Chapter 11 bankruptcy is generally the chapter of bankruptcy that makes the news, and it's the chapter that most people are familiar with. Major corporations such as Kmart, General Motors, United Airlines, these are all companies who in the past have filed for Chapter 11 bankruptcy. Most Chapter 11 bankruptcies, however, are filed by businesses and companies that are far from being household names. Chapter 11 is available to small businesses seeking to restructure and continue in operation. Chapter 11 is available for businesses only. So individuals cannot file for Chapter 11. Chapter 11 is available for businesses only, including partnerships, LLCs, and corporations. Chapter 11 is also the only bankruptcy option for individual business debtors who want to reorganize but owe too much debt to qualify for Chapter 13. So in Chapter 13, there are debt limits, and if you exceed those limits, then Chapter 11 is available. Under a Chapter 11 of bankruptcy, a business restructures its finances through a plan of reorganization approved by the bankruptcy court. Under Chapter 11, a business submits a plan of reorganization, and then the business's creditors vote on whether to accept or reject that plan. And the plan must also be approved by the court. The business normally remains in control of its assets, but the court can order the appointment of a trustee to take possession and control of the business. By reducing obligations and modifying payment terms, a Chapter 11 plan can help a business balance its income and expenses and basically regain profitability and continue to operate. Under Chapter 11, a business also can sell some or all of its assets so that it can downsize its business if necessary and pay down claims and debts that it owes. So who can file for Chapter 11? For the most part, small businesses and major corporations have to follow the same rules and meet the same requirements to reorganize under Chapter 11. So whether you're a big corporation or a small business, Chapter 11 is available. However, there are some special provisions for small business debtors that can help them fast track through the Chapter 11 process. It's important to note that Chapter 11 bankruptcy is probably the most expensive type of bankruptcy, and that's why the court has offered a fast track for small business debtors. So what type of business is considered a small business debtor? Under the Bankruptcy Code, a small business debtor is a person or entity who is engaged in business or other commercial activities and owes no more than $2.4 million in total claims. And that's excluding any obligations owed to insiders like family members of the business owners. So what are these small business provisions that allow a business to fast track through Chapter 11 bankruptcy? One, there's no creditors committee. Ordinarily, in Chapter 11 bankruptcy cases, a committee is appointed to represent the interest of the unsecured creditors. The creditors holding the 7 largest unsecured claims are usually appointed to the creditors committee. Representatives of the committee appear at the bankruptcy court hearings. They participate in the negotiation of the plan of reorganization, and they are able to assert objections to the plan if they wish. In a small business case, the bankruptcy court can order that no creditors committee be appointed, which helps fast track the Chapter 11 bankruptcy process. There are some additional filing and reporting duties for small businesses. Small businesses are subject to some reporting and filing requirements that are not imposed on other Chapter 11 debtors, such as bigger corporations. A small business debtor, for example, must attach its most recently prepared balance sheet, also a statement of operations, and its federal tax returns to the bankruptcy court for review. So there are some additional filing requirements for small business owners in a Chapter 11. There's also additional oversight by the U.S. trustee. The United States Trustee Office is the agency that oversees bankruptcy cases, and not only in Chapter 11, but in all chapters of bankruptcy. The U.S. Trustee's Office is the agency that oversees bankruptcy cases. Under the bankruptcy laws, small business cases are subject to slightly more oversight by the U.S. Trustee's Office than in other Chapter 11 proceedings. There's also a deadline for the plan of reorganization. Chapter 11 bankruptcy generally requires a plan of reorganization, as I mentioned. The plan basically sets forth a proposed new capital structure for the business to have when it emerges from reorganization. And the debtor has the exclusive right to file the first plan of reorganization, and then any party of interest may file a plan thereafter. Generally, there is no deadline for filing a Chapter 11 plan unless set by the bankruptcy court. However, in small business cases, the debtor has only 300 days to propose a Chapter 11 plan. The court can extend the 300-day deadline, but only if the debtor proves that it will be able to obtain approval of a plan within a reasonable period of time. And then lastly, there is no disclosure statement with small business owners. Ordinarily in Chapter 11 cases, the debtor must prepare a disclosure statement and submit it to the bankruptcy court for approval. The statement must contain adequate information about the proposed plan of reorganization, and it is supplied to the creditors and the equity holders. In small business cases, the bankruptcy court can waive the disclosure statement requirement, and this generally will expedite the reorganization process, and it also reduces the high cost associated with Chapter 11 bankruptcy. And this concludes my presentation on managing business debt. Just to recap what I've discussed, there are really two major options for business owners trying to manage business debt. There's debt settlement, and then there's bankruptcy. A business owner should only consider debt settlement if he or she has the capital available for settlement, meaning if you have the cash available to settle your debt, then I recommend you try to settle them before filing bankruptcy. And again, this is typically 30% to 70% of the overall debt owed. If you have that available, then I always recommend approaching your creditors with debt settlement first. However, if the business does not have the funds available to settle, then it should consider one of the available chapters of bankruptcy for businesses. And the business owner should even consider filing bankruptcy personally. A business owner should also consider bankruptcy if the business's assets, of course, significantly outweigh, a business owner should also consider bankruptcy if the business's debt significantly outweigh its assets. And that concludes my presentation on managing business debts. Now we're going to turn it over to Lourdes for a few questions from our listeners.
Hello, Crystal. We've got quite a few questions coming in from different parts of the country, so this is going to be pretty exciting. We have a question coming in from Florida. I am thinking about forming a business. What advice do you recommend to business owners who want to avoid business debt and having to deal with creditors?
Okay, that's a very, very good question. What advice do I have for someone who is looking to form a business, but they want to stay clear of business debt? I think one of the most important things is to have a solid business plan in place. Before you do anything, before you put any money into your business, before you invest in anything, you should always have a business plan. And your plan should, of course, outline your business expenses and how much capital or how much revenue you're going to have to generate to run that business. So a business plan is always important. I'd also recommend, just keeping your business expenses low, keeping your overhead as low as possible. If you're just starting your business, then it's important to always keep those expenses at a minimum, because you don't want to find yourself taking out business loans and you haven't even started generating any profit yet. So, just avoid taking on any debt that your business or you cannot afford. And I also recommend do not personally guarantee any of your business debts, meaning don't co-sign personally for any of your business debts unless it's just absolutely necessary. Because, again, if you personally guarantee these business debts, then your creditors can come after you. If you don't personally guarantee them, then say your business does fail, which is, it's not a good thing, but if your business does fail, at least they can't go after you personally for your business's debts. So that's what I recommend.
So is this where an LLC of some sort or some other corporation title would come in handy?
Yes. Again, LLCs and corporations are there to limit your personal liability. So that's always a good thing, is to form your business under a separate legal entity, whether it be an LLC or a corporation. And that way you won't be personally liable for these debts by your creditors.
So you would not advise against taking out like another mortgage or something of the sort for someone starting out with a business?
No, I wouldn't. I would not recommend taking out a second mortgage to fund a business, because again, then your business is tied to your home. And so if things go downhill with your business, then your home is tied to that. And that's never good. You don't want your creditors to have the opportunity to go after your home. for your business debts. So again, don't personally guarantee any of your business debts unless it's just, if it's absolutely necessary, which sometimes it is the case, then, you have to. But if at all possible, I recommend not going that route.
Okay. Our next question coming in from Los Angeles is very similar to the original question. I own a car repair shop, and the last year business has been slow, so I've been using 2 of my personal credit cards to pay bills. The credit cards are in my name, not the business, and the 2 total about $70,000. My question is, do you recommend trying to settle these 2 accounts, or should I file bankruptcy?
Okay, again, very good question. So this listener has 2 credit cards. I guess they're business credit cards, and they total about $70,000. And he wants to know whether he should try to settle or if he should just file for bankruptcy.
Yes, because these are not just business credit cards; they are his personal credit cards. They're under his name, not the business.
Oh, okay.
But he's using them for business purposes.
Okay, I see. Well, as I explained, if you, as a business owner, if you have the capital available, meaning you have some cash on hand to settle, then I always recommend trying to settle before turning to bankruptcy, because these are 2 personal credit cards. When you use them for your business with your car shop, then even though they're your personal credit cards, you basically commingled your personal funds with your business funds. And so this can become tricky also. If you have the capital available, I would say try to settle them. Approach your creditors, explain your hardships, whether it be reduction in income or business has decreased. I'd approach your creditors and, explain your hardship and see if they're willing to work with you as far as settlement. Now, if they aren't willing to work with you, or if you just don't have the capital available to settle, then I would look into to bankruptcy. I'm not sure if your car shop is an LLC or if it's a sole proprietorship, but based on what type of legal entity it is, then this would determine which chapter of bankruptcy is best for you. These are personal credit cards also, so you personally would have to file for bankruptcy. You couldn't do it just under your business alone because they are your personal credit cards. So Chapter 7 would be available to discharge. That's an option. I'd of course want to review the details of your expenses and your credit card statements. But yes, I'd try that settlement first, and if that's not an option, then I would definitely speak with a bankruptcy attorney because again, you're going to have to personally file for bankruptcy to get rid of those credit card debts.
Great, thank you for that information. I think that was pretty clear. Okay, our next question is coming in from Cyprus. How do I approach my creditors about possibly settling some of my business debt? I have business credit cards that are maxed out at $55,000, and I have talked to Bank of America about lowering the interest rate so that I can afford the payments, but they are not working with me. Are there any laws that my bank is required to follow in order to settle these accounts that I cannot afford?
Okay, great question again. So are there any laws that require creditors to settle? No, unfortunately, there are not any laws that require your creditors to negotiate and settle your debt. There aren't any laws or protections in that sense. If your credit card is maxed out, then again, this is a sign that you or your business are carrying too much debt, of course. And so the best way to approach your creditors about settling it, I think, is to to be upfront and honest about your situation, to explain your hardships in detail to your creditors so that they know what's going on and they understand why you cannot afford to make your payments anymore. And then once they, notate your hardship, you should inquire about any types of settlement negotiations that can take place. A lot of times, creditors will negotiate and will settle with you if they think that there's a possibility they won't get anything in the end. So I'm not sure if this is, so this is a business credit card. So if your business is on the verge of closing and you aren't personally liable for the business credit card, it's just the business itself, then I would approach your creditor and state that, your business is on the verge of closing and you need to settle these cards. Again, if the bank knows that your business is about to close, they're more likely to work with you, because if your business closes, they're not going to get anything at all. So the best approach is just to be upfront and honest about your situation and to, explain that you want to work with your creditor and you don't want your business to go out. You want to remain in business, but you can only do this if they work with you. Sometimes creditors will work with you and sometimes they won't, but I think it's always worth a shot. So, approach them openly about your hardships and go from there. That's what I recommend.
Okay, thank you for that. Another question coming in from South Carolina. How much does a typical bankruptcy for business cost, like in terms of expenses?
Okay, bankruptcy cost. Well, there's really no set price on bankruptcy. In Chapter 13 here in California, there is a maximum that you can be charged. It's $4,500 for a Chapter 13 bankruptcy, and that's the one limit as far as cost. But other than that, it depends on the extent of your business's expenses, the extent of your business's debts, and how long it would reasonably take an attorney to put your bankruptcy case together. A bankruptcy for Chapter 7 can range anywhere typically from $2,500 to $5,000, but really it depends on your business's finances and what's going on with their finances. If your business has say 100 creditors, then of course with 100 different creditors, this type of bankruptcy case will take an attorney much longer to prepare than, say, compared to a business with, say, 5 creditors. So it depends on the extent of your business's finances and basically what's going on with your business's expenses and debts. That determines your bankruptcy cost.
Great. Thank you for that information. Our next question coming in from Lancaster. I own a beauty shop and it is under an LLC. I want to file a bankruptcy and basically start fresh because there is no way I will be able to pay back everything my business owes. What chapter would you recommend?
Okay, great question. So what chapter you would file depends on what your business's long-term goals are. If you plan, it sounds like you want to start fresh. If you wanted to start fresh under an entire different LLC, meaning an entire different business, then I would recommend filing a Chapter 7. Under a Chapter 7, you can go ahead and discharge your business's debts, but it becomes difficult to continue operating under a Chapter 7 bankruptcy. So a lot of times what business owners will do is they will file Chapter 7 for that business and get those debts discharged, and then they will go ahead and form an entirely different new business under a different LLC. So, it depends on what your goals are. If you wanted to continue continue with the same business, then I would say look into a Chapter 11, because that way you could reorganize your business and your business's debts, but still continue to operate and be in business. Again, under a Chapter 7, it can be difficult to continue operating, but under a Chapter 11, you can continue operating your business and pay back your business's debts through that plan of reorganization. So I'd need more details to give you a more specific answer, but I think depending on what your goals are for the business, whether you plan to continue with the same business or under a different business, then that would determine what chapter you'd want to go with.
Great. Thank you for that. We have a question coming in from Ohio. I recently settled my Visa business credit card for $10,000 in 12 months and am still making payments on it now. I received a 1099-C form in the amount of $25,000, which is how much I saved after the settlement. Am I required to file this with the IRS? And if so, will I be taxed for this? I settled the card because I could not afford the full balance. I cannot afford to pay taxes on $25,000 that I saved. What can I do?
Very good question. So are you required to file the 1099 form with the IRS? Yes, you are required. Under tax law, you do have to file the 1099 with the IRS. You know, there's no way of getting around this. If you're issued a 1099, this is because you have been, or your settlement allowed you to forgive a portion of that amount. So you have to file the 1099 form, and the forgiven debt, and it's going to be listed on the 1099 form. The forgiven debt is considered taxable income, unfortunately. And you know, there's really no way to get around this. I would recommend talking to a tax professional to see if there's anything at all that can be done. I don't do taxes, so I wouldn't know any, specific loopholes to get around this, but based on my knowledge, you do have to file that 1099 form, and it is considered taxable income, which you will be taxed on.
Well, that's wonderful. And to touch on the 1099 forms, there are several different types of 1099 forms that an individual can get in terms of their income, and they can be applied in different methods depending on what type of 1099 it is. I think the 1099-C is a form of income, if I recall correctly. That was our last question. So with that, I would like to thank our listeners out there for tuning in to this webinar. I hope that it was as informative for you as it was for me. And you can reach us via the Wealth Management website, or you can also reach Miss Lindsay via her website, thelindsay.lawgroup.com. And we look forward to having you in our next series of webinars. You can subscribe via our website as well, and you can view previous archived footage online. Thank you again for your time, and thank you for your presentation, Crystal.
Thank you, Lourdes, and I encourage anyone with questions on business debt or bankruptcy to visit my website at thelindsay.lawgroup.com for additional information. And anyone who is considering bankruptcy or questions on bankruptcy or how to manage and deal with debt, please feel free to call me. You can reach my office at 310-882-1863. Thank you.
Thank you, and good night.